So in this panel, we get down to some details, particularly with respect to patent law. And it's always been my view that we can have discussions at a high level about what the patent system is trying to do and various policies it's trying to work out. But very often, the truth and the insights are in the details, the application of the policy, what makes the policy real and gives it teeth, is in the specific doctrines that we apply. And so I think the inventorship question is still hovering for AI-created inventions. We know that. But as I said in the intro, we're starting to see a little bit more discussion about the coming issues, the issues that will be the first practical and I think important application of patent system policies to AI. And specifically, we're going to talk about non-obviousness, we're going to talk about Section 112 disclosure, and we're going to talk generally about the question of how to integrate AI-created, generated information into the patent system. We had a touch of this in the last panel, where we had a discussion about what happens if you can't meet the requirement for a named inventor, and yet information has been generated and is out there in the world. And it was described as a patentability gap, but you could also just call it, how do we deal with AI-generated prior art? Even if prior art doesn't have an author or an inventor, that's irrelevant for its status as prior information, right? We don't care how prior information is created. We're going to take it all as a great big mass and say, compared to the claimed invention, how does the prior art stack up, or vice versa? The point is that AI is generating information at a rapid clip, and the inventorship question is just the very first tip of the iceberg on how it's going to impact the IP system, particularly patent law. So when I was asked to put together this panel, I had a very simple kind of heuristic that I applied, which is who's done the best work analyzing the practical requirements for patentability so far. And the people to my left were the people who made the list. I'm going to introduce in the order that we'll present. So just bear with me. Dr. Howe will present first. She's already written a nice paper on inventorship, where she dealt with some of the things in the prior panel. She talked about the idea of constructive conception, which is a new neologism in the patent world, but it's derived from the history of the constructive reduction to practice, which is an aspect of patent inventorship that's been around a long time. But today she's going to talk about some new research, which is the analogous arts doctrine in non-obviousness. And it is an example of how using AI tools may impact some of the detailed doctrine in patent law. That is, I think, an example that we will see applied very quickly because of the nature of prior art rejections. And I expect an issue along these lines to be appealed fairly early, in the history of AI patent applications. They took away the order, so I'm trying to remember. I think, is it Peter's next, Peter Lee. He is asking, I think, a fundamental question, which is synthetic data is now becoming a big part of our landscape. We know that with respect to things like deep fakes and doctored images. But he's going to a deeper level and recognizing that a lot of information is being generated by AI platforms, and AI platforms are capable of creating some of the data that AI programs need to operate on. And so you have this kind of circularity of synthetic data training AI modules or AI algorithms. And he's looked into how synthetic data should be treated as a legal issue. It's kind of a meta issue because synthetic data is going to affect a lot of different areas of the law. In a sense, deepfakes and things like that are just the leading edge. He's talking about if AI systems generate synthetic data, who can have access to it, how much disclosure should they be about where it came from, and how will it affect the patent system overall. I think Lisa's next. Did I have that right? Okay. This is Professor Ouellette from Stanford's visiting now at NYU. I should have said that Peter Lee's at Davis, has been there a long time. Lisa has worked on the disclosure requirement in the Patent Act, among many other topics, pretty extensively over the years, and she's turned her attention now to the disclosure requirements as they are going to relate to AI inventions, and specifically she takes an interest in how reproducible and how enabling are AI disclosures or disclosures generated by AI inventions or in relation to AI inventions. That is an aspect of the bigger question that Arti from Duke, who's just to my left, has been talking about, which is a more general issue of reliability in the AI age, right? We have certain presumptions and assumptions about the provenance and accuracy of information, especially in the patent system, both in prior art information. We take most non-patent references as having been gone through some sort of peer review, some reliability check, right? Many of those checks will be ineffective, maybe not even applied to AI-generated information. And then the other part of it is, in a patent specification, the disclosure about how to make and use the invention. We have a lot of detailed legal standards. Lisa's looked into that, Lisa Ouellette, in quite a bit of detail, and I think she's skeptical about how effective the disclosure requirements under U.S. patent law really are. But Arti's talking about the even more general question is, what about reliability of AI-generated data and claims over invention and just disclosure, just information? How reliable is it? And how is the question of reliability going to have to be handled as we deal with more AI-generated inventions and more AI-created prior art? So this is stuff that I think examiners are struggling with right now in pending applications on their desks, probably in 10 or 12 patent systems around the world. So this is going to generate an early wave of lawmaking, either regulatory, patent office guidance, or probably appeals from rejections, I imagine, around the world. And so the headlines next year and the year after, I think, are going to be centered in the IP world, certainly in the patent world, on these questions. Okay, so Dr. Howe, let's start with your treatment of analogous arts, and we'll go from there.
Thank you, Rob. I need to ask a favor because I didn't expect our position, my position would be changed, so I don't have my timer or my computer. So would you please do me a favor and remind me when my 10 minutes, right?
10, yeah.
Is up. Okay. So in the limited time of my introductory remark, I will try to share two ideas. The first is that despite the amazing, really unprecedented performance and deployment of generative AI across a wide range of sectors in the past few years, in its very nature, deep learning-based AI is still a statistical machine. It is an extremely sophisticated one, but it is still a statistical machine in a way that it does nothing more than extremely clever correlation recognition out of mass data. So in that way, I see there is a major difference between deep learning-based AI and human creativity. And if I'm forced to express this difference in one sentence, it would be that we human beings understand causality, while the learning machines can only understand correlation. For the difference between correlation and causality, a quick example would be I almost always bring my umbrella when it's raining, but my bring umbrella is correlated with raining. My bringing of umbrella didn't cause the raining. Actually, it's the other way around here. Another example would be rooster crowing and sunrise. Rooster crowing correlated with sunrise, meaning that they often happen together. But it's not that either one caused the other, actually, if you dive into deep research of rooster crowing. Anyway, I think understanding this difference between causality and correlation is one of the bases we really have to understand both the strengths and weakness of the state-of-the-art AI today. I call it SOTA AI, basically deep learning-based AI, whose success benefited, as many of you know, from the mass concentration of data during the internet age, the amazing development of computer technologies because of Moore's law, and also some very clever learning algorithms. A representative is the 2017 paper, Attention is All You Need. So I don't have time to dive into the details, but suffice it to say that because of this difference, my first argument is that one of the better ways we work with AI in the inventing process in the near future is through this synergy of human beings and AI. I call it centaur inventing synergies. Actually, I like this image so much that I use it as my WeChat photo. And some of my friends yesterday over the reception very kindly called me the centaur girl. Anyway, the basic idea is that I borrowed this metaphor from the first human chess champion, Kasparov. Who was defeated by IBM's Deep Blue in 1997. So he was the one that first argued, maybe a better way for the future is human beings working with AI. I find this metaphor very vividly depicts the idea I want to convey is that because of the different comparative strengths of human beings and AI, a good way for the team would be for us human beings to pose creative problems and for the AI to predict solutions within the problem space carefully defined by human beings. Of course, if I had more time, I would explain to you why understanding causality is so fundamental to finding and framing really creative problems out of the messy world challenges. But suffice it to say here now, creative problem finding and framing catalyzed a lot of major scientific breakthroughs and path-breaking inventions in human history. I need to give one example of that. So what I'm talking about is that if you are familiar with the stories of the Wright brothers, how they invented the first heavier-than-air flight, was that before 1903, almost all pioneers in aviation, the flying field, they thought the major problem, the major obstacle to human flying was to get enough power to lift and propel the flying machine. And because of this problem, so a vast majority of the efforts was spent in this field, and it caused no progress, actually. And very tragically, several pioneers died in those efforts. But very creatively, the way the Wright brothers, Wilbur and Orville, from Dayton, Ohio, they framed the major problem to be how to maintain a three-dimensional control of the machine once it is lifted in the air. And they got actually the inspiration from their experience as decades-long bicycle riders and mechanics. So please bear this in mind, because it'll be directly relevant to what I'm talking about later when it comes to more doctrinal discussions, analogous art. So because of this, we are actually, I shouldn't have said a better way to see in the near future. Actually, we are already witnessing some very interesting case studies of the CIS in action as I was doing the research in drug discovery and material science field. You see, often it's the human beings, they frame specific problems to be solved, and they sometimes train, accumulate data and fine-tune the model. And also they do the final value judgment because, again, we human beings, we know causality. But it doesn't mean that AI cannot make significant contributions. As we kept talking about in last panel, AI does amazing contributions by predicting solutions within the problem space. I can give you one example why correlation is already itself is very strong in predicting solutions is that if I were a cat and I observe that rats always go from point A to point B every day, I don't need to know why they go that way, but as long as I know they go that way, I won't starve. So, but also, a good example of the AI's tremendous contribution is the AlphaFold scenario, which successfully predicted the three-dimensional protein structures, a decades-long challenge for biologists, which also opened the door to a series of amazing research on AI-assisted drug discovery. But the weakness of the AI, again, is that because it only understands correlation, not causation, so it's really not able to interpret, to explain why I predict this solution. So in a large way, this is the deeper technological reason why deep learning-based AI is a black box. Okay, I have to move on. My second point is that this CIS is posing systematic challenges to various doctrines of patent law. I use US patent law as example. I only have time to show you one for the one doctrine under the obviousness assessment. So for those of you who are not that familiar with US patent law, based on section 103, an invention, for an invention to get a patent, it not only has to be new, but also have to be creative enough. The test for this kind of legal creativity is the 103 obviousness test. So a patent may not be obtained or not with understanding the claimed invention and the other. If the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date to a person having ordinary skill in the art to which the claimed invention pertains. So under US law, the prior art has to be considered firstly analogous, meaning closely enough to be considered for section 103. And this is very different than section 102. There are two tests articulated by the Court of Appeals for Federal Circuit, the National Jurisdiction Patent Court of Appeals in America. There are two ways to decide whether the art is analogous. First, whether the art is from the same field of endeavor, regardless of the problem addressed. And two, if the reference is not within the field of endeavor, whether it still is reasonably pertinent to the particular problem with which the inventor is involved. I want you to have one more look at prong 2 because that's what I will focus on when I talk about AI challenges to analogous art doctrine. Also because prong 2 has been used in many, I'm sorry, I spent too much time.
It's okay.
Anyway, so, all right. So according to the 2024 USPTO guidance request for comments, I think I should flash this question is that in view of the availability to a falsita of AI as a tool, how, if at all, is an obviousness determination affected, including when does the analogous art standard still make sense in view of AI's capabilities. I'll be very quick. Okay, my short reply in a nutshell is yes, but the doctrine should be clarified to overcome its current drawback in failing to recognize the creativity embodied in problem finding and framing. Otherwise, the drawback will be magnified in AI age and bias human creativity. Do I still have time, or I can maybe discuss this later? I'm sorry, I didn't have.
Yeah, I'll try to make sure to ask a question. Maybe just wrap it up because I want everybody to have a chance here. So go ahead. Just
maybe I'll
minute or
just
so.
leave it later. You know, I'll use thought experiment in later discussion. So I don't want to steal out of.
Okay. I mean, I think if you come back to the Wright brothers example
I'll
and
use
say, you know,
later.
was the bicycle art analogous to, you know, heavier than air flight? And I think your answer might be, it wasn't until they found that it was, and that poses the challenge, right?
Yeah, it's only with brain twister, and I'm sorry.
Oh no. That is the question that shows what you're focused on. So we'll come back to it during Q&A because I think we're going to have a lot of situations like that where AI looks sideways, finds something that we didn't think was analogous, turns out to be incredibly helpful, and now we have to fit it into a test that was never designed for something that looks so far laterally. I mean, I think the point is well taken. Okay, Peter.
Great. So it's a great pleasure to be here. I'll just take a moment while the slides are being loaded, please. So I'm going to talk a bit about patents in the age of AI, implications for non-obviousness, and disclosure. Thank you. So just to get started, so I'm going to talk a little bit about synthetic data, as Rob mentioned, but I'm going to focus on integrating AI with an existing US doctrinal framework. So I'm just going to give you the kind of takeaways right at the outset. I think that AI raises the standard of non-obviousness in several ways. Claims encompassing AI models require significant disclosure to counter the black box phenomenon, and non-obviousness and disclosure are closely linked. And obviously that's true across patent law in general, but I think it's particularly pertinent to AI-based inventions. All right, so our first speaker began talking about non-obviousness. Our US Supreme Court offered us a framework for non-obviousness inquiries in 1966 in a case called Graham versus John Deere. And so what do courts have to investigate? They have to investigate some primary factual inquiries, the scope and content of the prior art, the differences between the prior art and the claims at issue, and the level of ordinary skill in the art. Additionally, secondary considerations like commercial success are objective indications of non-obviousness. So, you know, Graham versus John Deere was a case involving a rather rudimentary technology, you know, a plow. How does AI impact this framework? I think it actually impacts almost every factor. So first, with respect to the scope and content of the prior art, in the age of AI, we're going to have more prior art. So, you know, let's say you hop on to Stable Diffusion or Midjourney or, you know, whatever your favorite AI engine is, you're generating content. This is, in a sense, synthetic data. That content may, with some caveats to be discussed later, constitute prior art. In addition, there are firms that are actually deliberately creating prior arts with the emphasis on preempting patents. So one firm is called All Prior Art. They specialize in algorithmically generated prior art. So we do have a lot of prior art being generated, or a lot of content being generated in the age of AI. It's important to keep in mind some doctrinal constraints on prior art. So not all of this AI-generated content actually counts as prior art. So we know that prior art must generally be public, such as described in a printed publication. So some image that's generated that lives in the bowels of Stable Diffusion probably isn't public and doesn't actually count as prior art. In addition, there's an anticipatory enablement standard for prior art. So AI-generated brief descriptions or images may not enable. So I asked Midjourney to make a protein. This is the image that it created. I have no idea if it's an actual protein, but it probably doesn't actually anticipate as prior art. All right, so there are concerns over AI generating millions of pharmaceutical compounds. I think one of our panelists, Arti, is going to perhaps talk about this, right? So AI can generate huge amounts of pharmaceutical compounds, So there are some concerns about more prior art in the age of AI. All right, so our first speaker kind of teed this up. In addition to there being more prior art in general, there's also a greater range of analogous art. So this is from the same field of endeavors, a claimed invention, or reasonably pertinent to the particular technical problem. And I would suggest that machine learning pattern recognition may expand the set of pertinent prior art. As the set of prior art and pertinent prior art expands, things tend to look more obvious. All right, so what about the differences between the prior art and the claims at issue? Well, for AI-based inventions, we could ask, what is the inventive step? And I would suggest that merely applying a generic machine learning model to achieve a technical solution may be obvious or obvious to try. So let's say that I want to claim an improved process for drafting law review articles using a large language model. Well, once you have some exogenous technology like monoclonal antibodies or the internet or AI, the general idea of applying that to certain problems seems rather obvious. What might be non-obvious, so the inventive step, encompasses the actual trained, specialized machine learning model. And this is going to kind of tie into what we talk about a bit later. This has significant implications for disclosure. All right, so what about the level of ordinary skill in the art? So doctrinally, a number of factors inform this analysis. One of them is the sophistication of technology in a field. With advances in AI, I think that goes up. And there are a variety of different approaches to analyzing the level of ordinary skill. So one human-centered approach would focus on a person's skill in using AI. So the skill here refers to the inventor's framing of the problem, the selection and control of algorithm and data, perhaps generating synthetic data to train the model, and refinements. So another approach, I think kind of a more mainstream approach, focuses on humans augmented by AI, right? So think about the faceta, the person having ordinary skill in the art that uses AI. And there's some analogy to facetas using search engines, right? So when these came out 20 years ago, that expanded kind of inventive capabilities. One could argue a similar dynamic applies with AI. And then at the far end of the spectrum, some commentators have focused on kind of an AI-centered standard, the inventive machine standard. I don't think that we're quite there yet. That's really more kind of in the realm of artificial general intelligence. All right, so moving to secondary considerations, imagine you're a US District Court judge and you have a patent case in front of you that deals with an AI-based invention. You don't understand AI, you don't like patent cases. There are high cognitive demands to determining non-obviousness. So in this landscape, objective indications of non-obviousness may become more important. Things like commercial success, long felt but unsolved need, right? So if I don't understand how you use a machine learning model to map proteins or to create proteins, but I do know that your invention solved a huge problem in biology and won the Nobel Prize, these objective indications might become more important in determining non-obviousness. All right, so turning to subtests of non-obviousness, one of them is the so-called teaching suggestion or motivation test. So under this test, a claim will only be considered obvious in light of multiple references if there is some teaching, suggestion, or motivation to actually combine those references. In a 2007 case called KSR versus Teleflex, the Supreme Court rejected a formalistic approach to the TSM test, but noted that it captured a helpful insight. And I think that AI can provide implicit TSMs, teaching, suggestions, and motivations to combine prior art references, thus weighing in favor of obviousness. All right, so transitioning then to disclosure, I think we need to draw a distinction between different kinds of AI-based inventions. So there are those that claim the outputs of AI, but not an AI model itself. And then there are those that claim an AI model itself. So regarding the first category, these are inventions that don't require disclosing an AI model. So we can talk about the invention that was really kind of the subject of the first panel. These are inventions created by Stephen Thaler, or actually created by Dabis. One of them is a food or beverage container comprising a generally cylindrical wall defining an internal chamber of the container. We're talking about, a beverage container. And so this was created with the help of AI, but it doesn't actually encompass an AI model. And for many of these types of inventions, there are no particular disclosure challenges. So on the other hand, we have inventions that actually incorporate an AI model. So consider here DeepMind's claims on machine learning for determining protein structure. So this claims a method performed by one or more data processing apparatus for determining a final predicted structure of a given protein. And here we have significant disclosure challenges, and this arises from the black box nature of machine learning models. It's very difficult to understand how inputs lead to outputs in machine learning. And so focusing on enablement, so this is a requirement that a patent teach a technical artisan to make and use the claimed invention. I think we can learn something from developments overseas. So the European Patent Office has actually rejected some patent applications claiming AI models for insufficient disclosure. And commentators note collectively, these decisions show that typically with applied AI patent applications, there must be sufficient detail to enable the skilled person to reproduce the trained AI. And I think that there's some analogy to developments in US jurisprudence. So in Amgen versus Sanofi, patents claiming all antibodies inhibiting a particular protein disclosed mere research assignments and failed the enablement requirement. So if you're going to disclose the invention, you have to disclose the entire trained AI. All right, so satisfying enablement likely requires disclosing model architecture, training data. This may include synthetic data used to train models, model weights or other technical parameters. This is logistically very difficult. It's a huge amount of data, and so commentators have suggested public deposit of training data or the model itself. There's some analogy to the biological deposit of materials, or the deposit of biological materials, I should say. So one quick note on best mode, perhaps we can talk more about this in Q&A, but there is a requirement of disclosing a best mode in US patent law, and I think that claims to AI would seem to require full disclosure of the trained specialized model. All right, so linking then non-obviousness and disclosure, for many AI-based inventions, the non-obvious attribute is the trained specialized model. So enabling technical artisans to make and use the non-obvious invention requires substantial disclosure of the model itself. So just to sum up, I think that AI raises the standard of non-obviousness in several ways by impacting the primary factual inquiries, secondary considerations, and subtests of non-obviousness. Claims to certain AI-based inventions require significant disclosure to practice the actual trained specialized model. So you may have to disclose training data, model weights, and in this sense, non-obviousness and disclosure are closely linked. So I'll close there, and I look forward to the ensuing discussion.
Okay. I've got some momentum going, so we'll just keep it going. I think Lisa's next.
Yeah, great. So thanks for having me here. So I'm going to talk about disclosure, and I think Peter did a nice job of laying out some of the issues. And I agree with basically everything that Peter just said, except in the first category of disclosure, types of disclosure that he was talking about, where you're using the AI model as part of the inventive process. That I think he said something like that there's no particular disclosure challenge there. And my main point is that I think there is a disclosure challenge, but it's not a really AI-created problem. It is a problem that has long existed. So I'm going to talk about work that I've done. This is primarily based on a project with Victoria Fang, a recent student of mine who was also a USPTO examiner before she went to law school, and Nick Ouellette, who's a Stanford engineering professor, also happens to be my husband, who I managed to recruit as a scientific expert for thinking about this. So I think, before you even get to AI, there are a lot of problems with human-drafted patent disclosures. Humans can also create problematic disclosures and the equivalent of AI slop. This is hard to quantify exactly how big these problems are, but I think there's a lot of reasons to think that there are challenges with this, including that, examiners do not spend a lot of time evaluating disclosure during the patent examination process. They don't have that much time in general, and they tend to focus it on looking for prior art and thinking about novelty and non-obviousness problems. Which is what most USPTO rejections are for. I'm in a current project working on quantifying this more, just how few rejections are for disclosure problems. So based on earlier data, it's like only 6% of rejections are for disclosure. And I'm thinking about primarily the enablement and written description requirements that you have to demonstrate, like how to make and use the invention without undue experimentation, and demonstrate that the inventor has possession of the full scope of the invention. And it's not surprising that examiners don't spend a lot of time on this. I'm currently working on another project with Jason Reinecke at Wisconsin, which includes interviewing some current and former patent examiners about this. I mean, there's relatively little training on disclosure. The training that they initially get is just the basic requirements. But if I just tell you patents have to disclose something like without undue experimentation, you could teach the legal standard, but that doesn't tell you a lot about like what does that mean in practice and how do you spot a problem, what kinds of problems are going to exist. So they don't have a lot of examples of things that are or aren't adequately disclosed. And often understanding the problem requires like time to read through the specification, think about the underlying science. I mean, most examiners they don't have a PhD, most don't have prior research experience, and most aren't at the patent office for that long. The patent office has challenges with retention and recruitment of examiners, which is like part of the challenge of like running a huge federal bureaucracy that's tasked with this really challenging task, evaluating all of these patent applications each year. For some prior survey work, it's just kind of another data point to think about this. I had surveyed a bunch of scientists in different fields about questions including whether they had read patent applications, and of the ones who had looked to patents for technical information and like as a source of understanding the invention, a significant percentage, like over 20% in all these fields, thought they probably could not or definitely couldn't recreate the invention described in the most patents that they read in their field, and a lot thought like weren't sure and thought only maybe. And I've also written about how we, based on the legal standard, like you don't have to have actually shown that an invention works in practice in order to get it. You can get a patent based on constructive reduction to practice, like sitting in your armchair theorizing about how an invention will work. And I think there's problems with that standard itself, that like in many cases we're awarding patents too early before you've demonstrated that invention will work. And because that's what the legal standard is, it's even harder for an examiner to figure out, like, is this information enough for someone to actually implement this invention in practice? I've done some work with Janet Freilich on the prevalence of these prophetic examples in patents, how they can be misleading for people who are trying to understand the patents, that like lots of patents have these things that look like real data and experiments, but aren't. Like the person who created the patent hasn't implemented it in practice. And so in that sense, they're more like a grant application than the like final published paper with the results of the invention. And this creates a problem not just because we're granting some patents that shouldn't be granted in the first place. It also means that all of those patents, which are the primary thing examiners are going to look to when they're like looking for prior art to figure out whether new things would be patent, some of those patents as prior art that are poorly disclosed will be used to deny later patents to people who actually figure out how to implement something in practice. And so these poorly disclosed prior art patents are a problem. So I haven't talked about AI at all yet. This is like all just normal problems with disclosure. And my main point is I think AI will just exacerbate all of these challenges. So for the project that I did with Victoria and Nick, we played with some of the many tools that now exist for using AI in the patent drafting process. And there's a bunch of these tools. Some of them are free. Some of them cost significant money. Many of them will advertise, like you can generate an entire description from claims. You tell it like, here's what I want my invention to be, and it'll write the rest of the patent for you, which maybe can be useful for saving time and increasing the efficiency of patent examination and democratizing the patent process. But it also like should trigger some alarm bells, like you're not telling it how you solve the problem. You're saying like, I want an invention that has these attributes, and it's then producing a document that's purporting to satisfy the disclosure requirements for that. So the project we did was kind of a proof of concept showing that like this can create challenges. So we used a bunch of these tools. I mean, some of them just produce very low quality output that doesn't seem like would even help any patent applicant. But there's some that produce stuff that looks facially plausible. And so we took 3 of the more promising tools and prompted them with short summaries and claims for 4 different technologies. 2 of them were existing technologies, they were over 10 years old, should be in the training data set, and 2 were hypothetical technologies that our science experts, Stanford engineering professor, said, like, it would be cool to have something that could accomplish this, and I have like some vague sense, but like I don't think anyone has figured out how to do this yet, and I don't know how to do it. And for all 4 of these, the AI tools, like all of them, were able to produce plausible descriptions that for me as a patent law expert and Victoria as a former patent examiner, we looked at it and said, like, we wouldn't raise a 112A rejection here. Like, this seems facially plausible. But for Nick, our engineering expert, who understands much more about the science here, he looked at it and said, for the existing technologies, he said, yes, in all this description, there's like probably enough that you could do it. I mean, it would take some additional work. Also, for those, there's a bunch of wrong information in them. So whether that's a disclosure problem or not depends on how you think about this kind of kitchen sink disclosure, where you give some stuff that does work and some stuff that's not going to work, and whether a FOSITA should have to sort through that. And then, unsurprisingly, for these hypothetical unsolved problems, the AI did not magically solve them. They like came up with something that to me looked plausible, but to him, he's like, no, of course that does not have the details of how this is going to work. That's probably not going to work. And so this illustrates that like AI can do the same thing that humans can do, of like coming up with plausible stuff for which you can get a patent that's going to get past the patent office without actually figuring out how to implement something in practice. So I think this is a challenge, and it's not an AI challenge. It's a challenge with how we think about disclosure in the patent system. Victoria also had a nice post on looking at the USPTO's guidance on like when you have to disclose things, which I think is a little vague on exactly what it means and like when that disclosure would be material. But whether you disclose the use of AI, I don't think that addresses the underlying problem, which is not about the AI. It's about like, is the text that you're providing actually enough for someone to implement this invention, meeting the legal standards? So I don't know the answer here, but like a bunch of potential things that I think are worth thinking about. Like, I think we should think about whether the legal standard is set properly, whether like the current standard that you don't have to implement something in practice, we should change the presumption there. Like, allow fewer prophetic examples, maybe for most inventions require actual reduction to practice with working examples, if that's the place where the incentive of the patent is more necessary to like actually figure out how to get something to work. I think we should also make clear that the enablement standard shouldn't be satisfied by a kitchen sink approach. Like, if you have a disclosure that says here's 20 different ways of doing something, and it turns out one of them happens to be right, the Federal Circuit case law on this is a little ambiguous, but I think it like could be read that could be okay. But I don't think that like it would take undue experimentation to sort through all of those, and so I think that shouldn't be okay, and we should have clearer guidance on the law there. I think there's ways to improve training for examiners to increase the attention that happens to disclosure in examination, including by giving more examples of things that are and aren't adequately disclosed and sample rejections to clarify when you might have disclosure problems. And it's worth thinking about, like, does it make sense to have just one patent examiner or evaluating all of these things? Like, maybe there should be disclosure-focused patent examiners who, if an examiner sees something that's might be a problem, that they can refer it to someone who's more trained in thinking about those disclosure problems, or like something like that. I've done prior work on whether peer review could help with patent examination, which was primarily focused on prior art, like having scientific experts identify relevant prior art, and it had an impact, though made me skeptical that like that was actually the most cost-effective way to do that. But I think there's not currently a mechanism for third parties to submit information about disclosure problems the way there is for prior art, and perhaps that's a place where scientific experts could have a larger role. Also, in like currently in grant challenges under IPR, you can't raise these disclosure problems. Maybe you should be able to. And then it's worth thinking about how AI can help, like, can it help patent examiners identify any of these disclosure problems? So I'll just conclude saying that I think that figuring out whether there are disclosure problems and whether examiners are doing a good job is challenging because we don't have a ground truth data set of which patents are adequately disclosed. But one thing I'd love from all of you is thoughts about the kind of, are there useful avenues for comparative work here? My understanding is the EPO examiners have more technical background than the USPTO and more disclosure-focused training, but I don't think there's a data set of EPO objections to patents to tell like where they've raised disclosure challenges. But if any of you have ideas from like other countries where you could do useful comparative work on how different patent offices think about disclosure, I'd love to chat about that. Thanks.
Very nice. Okay, let's keep it rolling and get on to Arti now.
All right.
Professor Rai, it's all yours.
All right. Well, hopefully my slides will be loaded soon. And fortunately for me, the three prior speakers did most of my work for me, so I can go very quickly. So I think a lot of what I'm going to say actually is a like hearty concurrence with what the three prior speakers have said. So let me just get started. So one of the questions that has been raised by Professor Ryan Abbott, who argued the Davis case, is everything obvious? Or he wrote an article called "Everything is Obvious," and I think if obviousness is interpreted to mean that like you have an inchoate idea and that's enough to make something obvious, yes, everything is obvious. Probably in the not too distant future, we're going to have AI that'll have a huge amount, a huge capacity to create lots of analogies to lots of things we wouldn't think of as analogous art. But I think it's not necessarily that everything is obvious if we think of obviousness as encompassing reliability, which really it hasn't. And I would argue that reliability from the standpoint of how I would argue that it should be incorporated into obviousness analysis could either be ex ante in designing the AI model properly or ex post in evaluating the output of the AI model. So this is the article that I wrote on this question, and it will be coming out actually in UC Davis at Professor Lee's school very soon. So that is kind of my general view of why, at least for the foreseeable future, or in the near term, everything will not be obvious as a consequence of AI. I do think, and this goes to a lot of what Professor Ouellette has already said, that part of the problem has been that we just haven't cared about reliability in the patent system. And the way that that has played out is that our utility standard is a very cursory one. And here I have cited an article that Professor Ouellette already put up. We do encourage very early filing, and as a consequence, I think we get a misallocation of rights probably to the wrong filers. And then, of course, there is the lack of reliability of patent invalidating prior art, which Professor Ouellette also talked about. And there's been some really good writing about this. And this is also, again, as Professor Ouellette mentioned, completely separate from AI. But I do think AI is going to exacerbate the problem, as she said. So I can go really quickly through this. AI could make the challenge even more acute. And so one of the things that Professor Freilich, who also wrote with Professor Ouellette, and I have talked about, and this was in a Science article, is the fact that AI-derived drugs, and you can't necessarily know what an AI-derived drug is by looking at it because nobody talks about using AI in their specs, but we did this by identifying AI-native firms and then having controls that weren't AI-native firms. And we determined that there's a lot less experimentation to kind of validate the results if it's an AI-native firm. And there are lots of problems with in vivo experimentation with drug candidates, but it is the case that there's very little or significantly less in vivo experimentation done by the AI native firms. And that's kind of troubling. We do think that more experimentation that would validate the results of AI-generated compounds would be very useful, and that's where the human component comes in and could create non-obviousness just through the experimentation that was validating the results of the AI. So again, the answer is not necessarily more in vivo work, because in vivo work has lots of challenges, but these patents also showed no evidence of rigorous alternatives to animal testing, and including no evidence of AI-based alternatives, which could have shown, I think, more reliability and also would have helped to create a non-obviousness, meet non-obviousness bars. So the general idea of the paper is that humans plus AI can improve reliability both ex ante and ex post. These are largely examples taken from some PTO guidance on the question from last year. So one could imagine human and AI improvement of an AI-generated compound. And by the way, I'm using drug examples here simply because that's what I've done most of my empirical work on, but one could imagine translating this to non-drug context as well. So you could have human plus AI improvement of an AI-generated compound, or ex ante, you could have a new neural network that was human designed so as to optimize so-called ADMET properties, which are properties of compounds that help make them better drugs. So either way, either ex ante or ex post, I think we could have improvement in reliability, and that could be a way of satisfying the non-obviousness standard, so everything is not obvious. Now, Chris Mammam is not here, I don't think, but I do think that this relates back to a point he was making in the first panel, which is, yes, I think that creativity of the flash of genius type can be sufficient to show non-obviousness, but I don't think it should be necessary. I think more kind of mundane work that shows that the thing, the flash of genius concept that one came up with is actually likely to work, is also the sort of thing that can show non-obviousness, and should be the sort of thing that can show non-obviousness, as well as conception and inventorship and all the other things. And so I think we need to move away from this highly idea-focused vision of what inventorship or non-obviousness is. With respect to the proliferation of AI-generated prior art that Janet and I have written about, and that the PTO has also been very concerned about, I think it's the same sort of problem, that anything can be prior art. And this is the way in which I think I disagree a little bit with Professor Lee, in that I don't think there's much of an enablement standard for prior art at all. And this is not a specific gripe about AI-generated prior art, as Professor Ouellette has said. Prior art is basically, as long as the thing is out there, the structure is out there, it constitutes prior art, and it doesn't have to be reliable in any way, shape, or form in order to be prior art. I think all prior art should be held to a higher standard of reliability. And that would, it seems to me, deal with a lot of the problems with AI-generated prior art, and prior art more generally. So one data point from our study, there's no explosion of prior art molecules in the study that we did for AI native firm patents, but this was before LLM-assisted drafting, and I fear that going forward we will see a lot of AI-generated prior art creating lots of problems for subsequent work down the line that is more reliable. Another data point from a study that we are doing right now, Janet and I, is that right now AI-derived compounds don't seem to be more structurally innovative than controls. So in the drug compound space, you can test this quantitatively. One doesn't have to do this particularly philosophical view of creativity in this context. And I can talk about this slide, and you can ask me about this slide later, Rob, if you'd like. But this basically shows that right now these compounds are not more innovative than control compounds. So disclosure of AI use. So this is not disclosure in the context of claims to AI models, but rather disclosure of AI use in context of claims to the outputs. So there are lots of arguments against disclosure in general when the patent claims an artifact, as the term has been used in prior panels. We don't need disclosure of discovery process. There are concerns about showing obviousness if you disclose too much about exactly how you got to your artifact. Maybe challenges to inventorship now with AI. And I think all those arguments are reasonable, but I think there are also policy arguments for incentivizing disclosure, even in the context of the situation where the AI is merely a tool. And I do think that this is a situation where, in some cases, this is kind of like the complex biologics that Professor Lee mentioned. In some cases, the process, it's not quite the same as with biologics, but the process gets closer to being the product in some of these really complex AI-generated outputs. And I would argue, and did argue in the paper, the UC Davis paper, that with the disclosure, one should be able to get some sort of safe harbor against non-obviousness or obviousness-based or inventorship challenges. Basically, you show that you've done enough as a human to ensure reliability, and that should be enough to prevent you from having the patent invalidated on inventorship or obviousness grounds. So, there is the possibly near future where broadly available AI models will produce reliable output across all domains. And then we can speculate on whether, at least on strictly utilitarian grounds, IP will be necessary. I think it still could be necessary because I'm still skeptical that will happen in the near future, but potentially in the future that could happen, and we can talk about that as well if that is of interest. Thank you.
So we actually did leave time for your questions, and so I would like to hear. Go. Matthias.
Wait, hold on. On the comparative law aspects, but let me start with my question first of all. I'm very much intrigued indeed by that time delta between the rational or sometimes less rational ignorance in patent granting, and then later challenges in validation and nullity proceedings. First of all, of course, we have the problem that until those later proceedings, the register might be flooded with bad quality patents with all the consequences with regards to new applications you mentioned. But there is also another problem with regard to later nullity in validation proceedings, and that seems to be the factual uncertainty we have with regards to the actual state of technology at priority date, right? Typically that will happen much later, years later, even decades later. And how would we make sure that at those later challenging dates, invalidation procedure, nullity procedure, we really know what the status of that very dynamic field of the available AI tools, training data sets, and whatnot was? Is there any possibility to improve that situation? Is there any possibility to incentivize repositories or whatever might help in that regard? That's my question. The comparative law remark is rather on enabling disclosure. Indeed, we've had that couple of cases in the EPO, as well as in new 2025 guidelines, which include aspects of enabling disclosure. I wouldn't put too much hope into that yet, right? What the EPO has tried to do is they try to prevent gaming the system with regard to claim formulation. So if the claim is very broad, just relates to AI without any specific context, they will require context. But that is more against gaming the system by formulating overbroad claims. With regard to enabling disclosure, once you relate in the claim to specific trainer dating sets and their features, What they essentially say is, well, then you have to describe the features of those training sets a little bit. You have to give one illustrative example of a working embodiment, but none of that, from my point of view, comes even close to making sure that the invention would really work across the spectrum of what is claimed, right? It's just one example, it's just one. And that also leads me to the question of whether we will need some kind of new incentives for more to do on enabling disclosure, not to run into the problem we had with software-related patents, right? Where in the end of the day, we were just disclosing broad concepts and functions instead of where the really innovation is in the code. Last very brief question to Lisa. How could we incentivize later challenges with regard to enabling disclosure? Broadening the possibilities makes perfect sense, totally agree. How could we even further incentivize that parties really do that?
Almost everybody touched on that, so I'll just ask for volunteers to answer that. That's a broad question. Anybody? Lisa, you were.
I mean, there's lots of interesting thoughts and good questions in there, so I'm not going to try to touch on all of them. And I think figuring out how to incentivize people to challenge disclosure, I mean, that is also related to like the logistics of a post-grant challenge to disclosure and the evidentiary issues there. In the project I'm mentioning that I'm doing with Jason Reineke with interviews of examiners, I've also been starting some interviews with patent litigators on when they think about disclosure. And I think that just as we under-enforce disclosure at the patent office, it's not like we solve all these problems in litigation. I think there's a bunch of structural reasons related to how litigation works, at least in the US context that I'm familiar with, that causes enablement to like not be a thing people tend to focus on, including that it's often very fact intensive. It's very hard to get summary judgment on. That's like presenting this to a jury can be complicated. A lot of people who are there like bringing something to trial are choosing to just focus on non-infringement there, given the like shortness, like the constraints on the trial. And so like when they raise disclosure problems, it tends to be a very formalistic set, which is also similar to what the patent office does. It's not like, oh, this like doesn't actually explain how you would make this hard thing as of the knowledge we had at the time. It's like the disclosure problems are like, you claim something with elements A, B, C, and your spec doesn't mention C, and so there's a problem. So it's just a kind of narrow subset of the issues we'd be interested in. So like I don't know that we can solve it all later, which is part of why I want to think more about like the patent office like incentives at the examination stage, including potentially changing the incentives there of like the counts that patent examiners get when they raise a disclosure problem, given the like increased time that takes. I don't know if there's a way or a reason to change the incentives for like litigants who are challenging something later.
Yeah, let me just add to that. I think Peter had an idea that's relevant, the idea of deposit. I think we need some way of setting, of disclosing what was the exact state of your training model on the day you filed, because that's very fungible, So a kind of, if you do research based on when did things first appear on the internet, you're familiar with the Wayback Machine, which freezes the internet, day by day and says, what was the full content, April 12th, 2022, whatever. Something that gives you a very specific fix on what the state of art was when you filed would be helpful. And deposit could be an aspect of that. The other point that came to mind is a very underutilized policy instrument in our toolkit is patent office fees. And so I think the one way to address the flooding problem would be either penalizing mass filings, changing the fee structure to disincentivize it, possibly increasing the maintenance fee, which is higher in Europe than it is in the US. Patent office fees, with the exception of a few people, including Matthias's German colleague, Dietmar Harhoff in Munich, few people have really theorized about it. It's an area that's going to take more attention if we worry about a flood of low quality patent applications and even issued patents. Those are areas we could play around with. Thoughts, folks? Yeah, Peter?
Oh, go ahead.
So I just wanted to put in a plug for the possibility of expanding post-grant review. I think that there are, post-grant is obviously ex post, but I think it could have significant ex ante impacts in terms of what applicants do if there was sort of a credible threat of significant post-grant challenge at the Patent Office based on disclosure. I do think it would have kind of upstream effects, if you will. The reason I say all this is because I think the cognitive load, to use a term of art that's sometimes used in the psychological literature, of doing a disclosure evaluation is huge. And it's very different, it seems to me, from doing a non-obviousness inventive-step evaluation because of the prior art, kind of the more formalistic approach you can use. I think in that context, it's easier to think about expert judges kind of doing this evaluation rather than relatively rushed patent examiners. I'm just not sure we're going to reach a stage where patent examiners are able to do this. Now, fees could be a way of thinking about sort of creating incentives on applicants rather than examiners. I'm a little wary about the possibility of examiners being able to do a lot with disclosure.
So if I could weigh in on the second observation you made. So your point's well taken that we shouldn't read too much into developments at the EPO. And I think, I agree with the gist of your comments that the enablement standard is quite low. So particularly compared with standards of scientific reproducibility in scientific journals. And so, one possible lever, and I fully admit it's a problematic one, is best mode, right? So best mode is kind of the neglected stepchild of disclosure because of legislative changes. The failure to disclose a best mode is no longer a ground upon which to invalidate or cancel a patent claim. So best mode in general means that, it's kind of enablement plus. So if you're aware of specific techniques or instrumentalities as the best way of practicing your invention, as of the filing date, you should disclose that. And doctrinally, there's both a subjective and objective kind of element to best mode. So first of all, we have to know or kind of understand that the inventor has a subjective knowledge of best mode, and then he or she must objectively disclose it. Well, historically, one reason why best mode was problematic is that we didn't really know if the inventor had subjective knowledge of a best mode. If someone's claiming an AI model, we have a pretty good indication that they probably do know the best mode, right? They've actually selected the data sets, they've refined the algorithm, and so that it's one possible lever for getting more disclosure that is satisfying the best mode requirement.
Can I quickly echo the comparative law dimension? Just very quickly, because
It'll be our last comment. Go ahead. Take your time. We're doing great.
Oh, okay. Just want to bring a little bit Chinese perspective into this. So I think one point I share with all my panelists in this is that actually many of the problems, non-obviousness or enablement, actually they long existed pre-AI. But the way I see it, AI is a powerful mirror. It would greatly magnify these problems. And another paper I've been working on is the U.S.-China comparative law perspective on AI challenges to patent law. So, on one hand, I do think I don't have time to dive into details, but I do think Chinese patent law, the enablement doctrine, has a lot of holes that might be abused, greatly abused with the AI, because for one, if disclosure is rarely used in the U.S., then it will be extremely rarely used in China, because there are not too many studies, but one study, reliable study, I saw is that like maybe less than 5% was invalidated on disclosure ground. But an exception to that is the recent Nobel laureates, Dürer's patents. The basic patents was invalidated by the Chinese Beijing IP Court. But that's a different story, sorry. So my point is that on one thing is that the enablement doctrine also might generate more problem when AI comes in. Also because they follow when they, in the rare cases, they talk about enablement, they pay too much attention to the separate technical features of the claim instead of a coherent narrative of conception, which I argue. But basically another part, I'll be very quick, is the obviousness assessment too. And on this, I do think China is better than US because I didn't have time to show this, but along lines of US case law paid very little attention to the creativity embodied in problem finding and framing. Professor Laura Farina from UCL did amazing path-breaking work in this, so you can check her paper on this. And this would, like I hinted, this would generate problem for AI. But on this part, Chinese patent law actually is much better because recent several cases from Supreme People's Court, actually they heavily emphasized the creativeness embodied in problem finding and framing, including actually, they didn't talk about AI at all, but they also said whoever asked the novel question could also be considered as making inventive contribution to the substantive feature of claims, thereby the inventor. So I do think maybe there AI would cause, I don't know, like lesser problem than US. But my point is that for me, I greater benefits from this US-China comparative law dimensions, just to echo a little bit what Matthew said, yeah.
Okay, very helpful. I think that last point too, if you ever apply for patents in Europe, the so-called problem solution framework is fairly similar to Chinese, the CIPO, the Chinese Patent Act. So identifying the problem as a distinct, moment in invention, who framed and found it, that would, to bring us back to what started here, that would capture the Wright brothers' innovative question, which is maybe the problem is stability. How could we address in-flight stability, three-dimensional stability? That was the key to coordinating the various flaps and rudders that make flight possible. Many of you are here because of it. Anyway, I think it's time to take a break. We will reconvene at 1:10, and then we can get started with the afternoon panel. So thanks for your attention. Lunch, yes, right. We have now an hour and whatever it is, 20 minutes for lunch. Okay, thanks very much.